Hey guys, welcome to a Blue to Gold webinar on Barnes versus Felix, a Supreme Court case that just came out. I am joined by Zach, John, and Travis. They will all introduce themselves very shortly. But before we start getting down to business, I want to do some quick disclaimers. First of all, you can't have a legal training without some disclaimers. Laws and agency SOPs, standard operating procedures, may be more restrictive. That is definitely true with a case like this. Every policy or every agency is going to have a policy on use of force. It actually may be more restrictive than we're going to talk about here. Even my agencies, I had somebody reach out to me today, even agencies in Texas, which this was directly affecting, they said, you know what, I know the Fifth Circuit said that, but we were doing something else anyway. We were always a little bit more restrictive on our use of force. If you have any doubts what you're doing out there, push up the chain. There are many, many attorneys here tonight. And if they represent agencies like police advisors, prosecutors, and so forth, if we say something that they disagree with, guess who's going to win the conversation, at least with their people, right? I'll try to convince them, but if we don't win, they are going to win that conversation with their people because that's who they hired to represent them. And finally, this course is legal advice, not legal education. Or I'm sorry, it's legal education, not legal advice. A few of us are attorneys, but we're not your attorney, so please make sure you are getting your legal advice from people that are in charge of your legal education and so forth, or decisions. Now, I didn't put Travis on here. It's my bad, Travis, because it was a little bit of a last minute entry. I was actually hoping you'd be available, but I wasn't sure. So you want to say something?
Yeah. Listen, Blue to Gold is the premium training company. I'm proud to be here. I do a particular class that is probably conducive to this discussion called Seconds for Survival. It's a pre-attack indicator class, use of force type training, where we show plenty of examples, things to do, things not to do, and I think it will be applicable tonight. So I'm certainly glad to be here.
Awesome. Now, what I want to do is I want to kind of do a quick intro because some people do not know everyone here. And as I said, about 40% of people here tonight have never been to it doesn't mean they haven't been to a Blue to Gold class, but they have not been to a Blue to Gold webinar, and that's great. So the first thing is me. My name, again, is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue to Gold law enforcement training. I like to say this is what I do for a living. I have the honor and the privilege to train cops all around the nation and try to make good case law. Now, when it comes to these Supreme Court cases, part of our job is to call it, is to try to predict the future. And certainly the people on this panel called this case. They knew where it was going and so forth. But if you're interested in my training and anything else that we do here at Blue to Gold, go to bluetogold.com. Zach, you're next on deck. Who are you?
Well, I am Zach Miller. I'm a retired police officer from Virginia, about 19 years of experience, mostly patrol, and was also in the training division for about half that time. And I've been a legal instructor, at least part-time, for about 16, 17 years, and full-time for the last, about two and a half years.
Yep, you've taught tens and tens of thousands of people. So,
I have, yeah.
yep. John.
John Ween, attorney and senior legal instructor with Blue to Gold Law Enforcement Training. I've been doing this for about 3 years. Prior to this, I did 10 years in Arizona law enforcement. Before that, I got my JD from Pepperdine University School of Law in Malibu, California. So I have been an attorney since 2011. And now I get to travel across the country and train with law enforcement officers.
Yeah, that's just that Pepperdine stuff. I don't know if you actually learned anything there because you're too busy at the beach, but regardless, you graduated.
C's get degrees.
D's get degrees. Travis.
Yes.
Who are you? So for those who do not know you, can you quick bio, please?
Okay. 30 years, Tulsa Police Department, retired as a major. Retired 2 years ago. I've been on the road training for about 25 years, specifically officer safety classes, risk management classes, and leadership classes. I do that full time now, and I do a lot of it with Blue to Gold. I'm very fortunate to do that. If anybody wants to know more, travisyates.org. We put out information each and every day. I've known Anthony for well over a decade, and this is the place to be. I'm honored to be here.
Yeah, awesome. So let me do my best job I can giving you a background on this case. Do me a favor. The way it's just going to work is, yes, we're going to answer some questions. I think we want to kind of get through some of the content first. Keep your questions, write them down or just in the back of your head. But if we just do a free for all, there's so many people here, it just may not be conducive to the momentum of the class. But I'm gonna talk about what I think the case is. Zach, John, and Travis are my use of force experts, especially John and Travis. They actually teach classes on use of force. I'm mostly a search and seizure guy, which of course a use of force is a seizure, but I'm mostly in the typical search and seizure realm. So here's what happened. So a little bit of case background. So this is our officer. This is the suspect slash plaintiff, the one that sued. And let's kind of go through this. So Constable Roberto Felix, he stopped Ashton Barnes for suspected toll violations. Now, I did find it very interesting. I don't know if anybody else in the room thought this was kind of interesting, but the car was a rental. And I just said, that's like my search and seizure brain going off is like, all right, if you're stopping the vehicle because you believe that the driver has violated tolls, it had a history of it had unpaid tolls, and I was just curious. Like if I drove a rental car and I got pulled over for somebody else's tolls, I'd just be curious about that. But that's not why we're here. So now the driver, Ashton, did not have a driver's license on him, and he said the insurance was in the trunk. He was also seen to be reaching around a little bit, and the officer told him not to reach around, but he did pop the trunk. He also was told to turn off the car. You'll see in the video here in a second that he did initially turn off the car, and we know that because the left turn signal was initially on. It was blinking. It wasn't hazard lights. It was a turn signal, and then it turned off. So that indicates the car is no longer on. And then after he was told not to stop reaching around and so forth, the left turn signal came back on, and within a second or two, the car was in motion. So Constable Felix then stepped on. So after Barnes started to drive away, it seems like Felix instinctively stepped on the door seal, and I have a picture of that, of this vehicle that was fleeing, of Barnes's vehicle, and within 2 seconds, he's holding on, probably for dear life. He's on a toll road, so a high speed road. He's holding on for dear life, and then he does almost like contact shots onto Barnes. And he killed him. He was declared deceased on scene within 12 minutes of this traffic stop. This whole thing went down very, very quickly, as you can see in the video. The conversation today is this doctrine that the Fifth Circuit called the moment of threat doctrine, and whether or not that was a viable way of looking at use of force under the Fourth Amendment, under Graham versus Connor. The Fifth Circuit wasn't the only one that kind of had this idea of looking at the moment of the shooting or the use of force. But other circuits like the Ninth Circuit and so forth did not view it that way. They viewed it under totality of circumstances. And we are going to talk about the officer created jeopardy doctrine in a sense of this argument. This case is not about that, but I absolutely know that a lot of you are wondering about that, because that is a lot of people wanted the Supreme Court to answer that question. Can an officer be liable if they make dumb moves, essentially, if they put themselves in a position or they do things that kind of create bad outcomes? So this was a unanimous decision. The court held that the moment of threat doctrine was incompatible with Graham's totality of the circumstances requirements. For many of us, it seems kind of obvious in that sense, but we still want to talk about it. This gives me an opportunity to show the video. So I'm going to put my camera off for a second and show this video and give an idea about what this officer was dealing with that day.
afternoon, sir. I'm Deputy Felix with the Constable's Office. The reason you're being stopped today is because your vehicle alerted to outstanding tow violation. You have your driver's license proof insurance with you? Sir? I understand that, but it has outstanding tow violation. When did you put the vehicle?
About a week ago.
About a week ago?
It's actually rented my girlfriend's name. I'm actually on the way to see her.
I'm sorry, I couldn't hear you.
It's actually rented in my girlfriend's name. I'm on the way to get it watched and turn it back in.
Okay. What's her name?
Sorry, Alicia.
Okay. You have your driver's license?
I'm getting over this car. I'm watching the car and turning it.
Is there anything in this vehicle I need to know about? Okay. I'll go digging around. I smell marijuana. Is there any marijuana in the vehicle? Don't dig around. Don't dig around. Don't dig around. Okay. So you don't have anything, any identification on you? Okay. Sure, go ahead and pop the trunk for me. Okay. Go ahead and put that paper off to the side for me. Go ahead and shut that for me. Don't fucking move! Don't fucking move! Watch out, 14, shot fire! Shot fire! Let the gun fire! Let the gun fire! I still take the HFD now! Southbound Beach Net.
All right. So from this point on, the cavalry is going to come. They're going to try to render aid, and they're going to pronounce him dead on scene. So I think I also have this is a picture that was taken from I believe a Texas Transportation camera. So you can kind of see him putting his foot on the door sill, and then he's going to grab onto the door and fire those two shots. Now, before we kind of get into the academic part of this discussion, and I want Zach to, also, I talked to him earlier about this, but basically there was a split, right? So the Supreme Court is that's one of their jobs, is to settle these splits. If one court says that the AR-15 is not protected by the Second Amendment, and another says that it is, and then we don't know really what the law is, the Supreme Court is supposed to get in the middle of that and say what the law is. So overall, generally speaking, the second, the fourth, the fifth, and the eighth did confine Graham. They didn't say necessarily the moment of threat. At the end of the day, the Supreme Court in this case, in Barnes, only looked at the 2 seconds prior to the shooting, right? The 2 seconds prior to the shooting. But they, not necessarily they went that extreme, but they were willing to confine, Graham to the actual use of force itself and not necessarily the events leading up to it. Then you have the first, the third, the sixth, the seventh, definitely the ninth, the 10th, definitely the 10th. They're definitely siblings, the 10th and the 9th, and the 11th in DC rejected this moment of threat, and they looked at totality of circumstances. Okay, that's kind of a quick intro. And Mike says that photo was after the shooting, so thank you for the clarification. I thought it was before, so my bad. All right, where are we at on this so far? Anything to add? John, Zach? Okay. Let me read a couple quotes, right? Now, they did say that there is no easy to apply legal test or an on-off switch in this context, right? Rather, the Fourth Amendment requires, as we once put it, that the court slosh its way through fact-bound morass. Well, that just makes sense, right, guys? I mean, you look at this. I mean, I think the biggest issue that I saw when this case originally came out is that and maybe this is not a good way of looking at it, and you can tell me, Anthony, that's not a good way of looking at it. But I just, in my brain, when I saw this moment of threat business, I said it basically can allow cops to get away with murder, right? In very extreme cases, it can allow a cop to basically violate the law. I mean, imagine that an officer, is going to a call for service, and the call for service is domestic at 123 Main Street, but the officer is completely not just negligent, but just reckless with what house he's going into, and he goes to 555 Main Street, walks into the house in the middle of the night. The homeowner comes out of bed with a gun, points at the officer because he hears a bump in the night. He doesn't know who's in his house, and the cop shoots him. Am I wrong by saying that if we look at the moment of threat, that cop actually may be justified in that shooting because at the moment he shot, the 2 seconds before shooting, the officer perceived a valid threat and was defending himself? I mean, could that be an extreme case of this?
Well, Anthony, I see it. It's really kind of a double-edged dichotomy here. So, yes, it's exactly what you're saying could happen. The other thing could be an officer could be looking at the totality of circumstances. That's why he's using the force, but that moment of threat didn't apply to using the force, but it's the totality of circumstances on why that is. So, they don't have a weapon or they don't have something, but everything that led up to that caused that. So, I think it builds more accountability, and I think you could probably look at it from either angle. I would rather want the more accountability. I'd rather want the totality of circumstances because that gives law enforcement an opportunity to every step of a contact to be able to build that case for why that use of force is being used.
What standard is better for officers? Is it easy to say that the moment of threat is actually an officer would prefer a moment of threat, or actually the totality of circumstances actually helps the officer?
I'd love to hear the answer.
Okay.
I know my answer. I just said it, but I'd love to hear everybody else's answer.
Well, I mean, if the problem with the moment of the threat is that, at least as it was used in the lower court in the Barnes cases, it was no other court that I know of has uses it in that confined or that cabined of a theory. They literally said the only thing that is relevant when an officer uses deadly force, defensive deadly force, is that the older cases, the previous case said the millisecond that the officer made that decision to use that deadly force, and that's just not consistent with any Fourth Amendment objective reasonableness standard. But if that truly is what moment threat means, then I think that would benefit the officer almost every single time. If the only thing we're concerned about was, did the officer have a reason to believe that that suspect posed a threat of death or serious bodily harm at the moment he made the decision, then it benefits the officer. But that's not
Well,
no one.
Actually, it's funny because actually Matthew brings up a good point. He says, look at the Plumhoff case, right? So Plumhoff versus Rickard, that was the case where the guy, didn't pull over. Well, he pulled over, and then he tried to escape, right? He backed out of that traffic stop. He was surrounded. There's video on this if you want to look at it. And then he flees for what, like 6 minutes, something.
It was
whatever.
wild. It was going 100 miles an hour.
He went 100 miles per hour. Then he kind of like crashes out a little bit in a yard. Then he's trying to escape again, and they shoot him. And the court said under the totality of circumstances that was reasonable because, right? Because we look at what he just did. It's not like he's probably going to leave there and just drive 10 and 2 and drive like he's on his way to church, right? So if you looked at if you in that case, it seems to me, and you tell me if I'm wrong, but if you use only moment of threat in that case, you have a problem because you're basically shooting a guy who's just trying to reverse.
Yeah, in that case, yes. I would think that I'm saying that more times than not, it probably would benefit the officer at the true moment of threat. But that case, absolutely, because the lower court actually said the officer used excessive force in the Plumhoff case, and then the Supreme Court said no, you got to consider the stuff that happened before that, and it ended up being reasonable.
Yeah. Okay. Travis, what'd you have to add?
Well, if you remove totality of circumstances and go with moment of threat, man, you're losing a lot. You're losing compliance. you're losing behavior of suspect, you're losing all of those gram factors, right? That may be part of that decision. So I think for most officers, they're telling us that totality of circumstances is preferred. With that said, I would love to get comments from the panel here to say, okay, they didn't address officer created jeopardy, but officer created jeopardy is inside totality of circumstances. So totality of circumstances could also create an issue with officers in that aspect. So, this is a half dozen one way or the other. I don't want to lose totality to gain anything, but there's probably advantages and disadvantages on both sides of it.
Yeah. And look, and Mike Brave, he's also a use of force expert, one of the smartest guys I know. He's obviously well, not obviously, but he's disagreeing with me, which is totally fine. But he's saying that totality, I'm not sure I understand everything he's saying, but he does put a quote in here: an officer doesn't lose his right to defend himself just because he made a mistake. Well, certainly, I think we all agree on that. But
Yeah.
can there be mistakes that are that cause liability? I mean, like the mistake, like let's say you have an officer who is having a bad day at work and is not paying attention to anything and goes into that house. Look, I'll give you an example. Okay, I'll give you an example, a real example. Similar case. So what happened was this officer, went to a house, and it was for, I thought it was like I don't know if it was like maybe domestic or a loud party, whatever it was. But look, completely not paying attention. Goes up this dark driveway. It's late at night. He does not announce himself. He has no flashlight. He's not, making himself known. I don't think his safety was a particular issue here. If it was a domestic, I can see an argument. But the point was, he was kind of being surreptitious. He was going in the shadows, as the court kind of described it. The homeowner hears a bump in the night. He comes out with his handgun, to see who was in his yard, type thing. And the cop sees him and he shoots him. If the court found that this officer was just negligent or beyond, right? Should that have any consequence in the totality of circumstance? I mean, should there maybe be some civil, maybe not, I don't know about criminal, whatever, but I mean, should there be some civil liability there?
I think we see that intermittently across the country.
I mean, if I did that, right? I mean, look, I'm just, if I was, we have an officer in Dallas, right, that went into the wrong apartment. Remember her? What was the ultimate? Do you remember what ultimately happened there? I know she was charged, right? So, anyway, my point is that I think that we have to be careful about, all we care is about an officer defending him or herself, right? We also care about the officer. We do care from a societal point of view, that we do care about what led up to that interaction, right? And my friend over says that she was convicted and sentenced. Yeah, Amber Geiger. Okay. Okay. So, anything else on this? So another quote that I thought was pretty good was, for example, the severity of the crime prompting. These are all things that we can consider, right? For example, the severity of the crime prompting the stop can carry weight in the analysis. Okay, that's a Graham factor, right? That's straight from Graham. So too can actions the officer took during the stop, such as giving warnings or otherwise trying to control the encounter. I had to tell you that I'm stuck on that little phrase right there, because that means something to me, right? And now it means something because it means that the officer does play a role in the outcome. That's what it means to me. Now, but it also says, which is probably the most important, and the stop person's conduct is always relevant because it indicates the nature and level of the threat he poses either to the officer or others. Probably the most important factor, isn't it? I mean, if Barnes would have complied, would he be alive today, at least based on that traffic stop?
Yeah.
Right. I mean, at the end of the day, right? I mean, let's not forget that part. I mean, his fact that he wants to flee. Now, let's start answering the question here. Is look, at the end of the day, all he is doing is fleeing from a very minor issue. Why not? Why just? Why should we just let the guy go? Right? I mean, is that what we should be doing here and telling cops in this case?
Well, totality of circumstances comes into it, Anthony, because the offense was minor, but you verbally heard the officers quit moving around. What's that smell? I mean, he says all that stuff, so there's a lot more going on than just a minor violation.
Yeah. Um, Zach, you read the concurrence, right, by Kavanaugh?
Yes.
What was
Yeah.
what?
So yeah, it was indicative of his questions during the oral argument. I mean, his main focus appeared to be on what is the officer to do? What is it? What guidance can we give all, or what guidance can we give officers in a situation like this? Do you let them go? Then he mentioned, minor traffic stops can lead to all kinds of, significant criminal activity. I mean, Timothy McVeigh is a perfect example.
Ted Bundy.
Yeah, Ted Bundy, and was it in Florida where they
Unabomber.
yeah, yeah. So, and that was his concurrence, was basically, listen, I agree with this totality of circumstances approach. This moment of the threat thing is just not a thing. But, I want to just add some food for thought. What he's trying to do is he's setting up, I don't say a defense, but something to consider in this officer created jeopardy. That's what this really is all about. This whole Barnes discussion, it really comes down to, is officer created jeopardy? Is that something that an officer or that a court can consider in the totality of the circumstances? This just wasn't the right case to address the issue. But
Yeah, and look, you're right. I mean, first of all, the record, there is no record for that issue, right? Because they didn't need to address it because they had the moment of threat. So we're good to go. We don't need to, spend time, judicial resources on, that jeopardy. But frankly, I'm not even sure the officer did create any jeopardy. I mean, when I look at it, I mean, if I was in that situation, it's instinctual. He's trying to stop this guy, and Kavanaugh made it very clear that, at least in his view, bad things can happen by letting him go.
I mean,
Right?
what if he, instead of jumping on a car, I mean, what if he was to back away? I mean, that Jersey wall was right there.
Back into the officer?
Yeah, the door's wide open. If Barnes, if Felix had instead, Barnes had instead backed up, he'd have pinned the officer between the door and the Jersey wall. I mean, he really had no. This is not an appropriate case, I think, to litigate officer created jeopardy.
No, it definitely is not. And then, but I just don't see, like, this is the world's not going to stop spinning because of this case. I mean, it's always been totality of circumstances, right?
Well, I was going to say that, Anthony. I mean, if there's anybody on here that's confused about this, let's just rewind this to last year. Like, this is what it's always been.
Yep.
Totality of circumstances.
So would you guys say it's safe to say that, by and large, use of force case law has remained largely unchanged for the last 36 years?
Until you went to the Fifth Circuit.
Well,
yep.
Does anybody know how we got here, by the way? Because I think that's, again, this is, this is a pretty obvious case to a lot of people, but do you know how we got here? How did the Fifth Circuit just look at 2 seconds of a shooting and say it must have been justified?
John, I have a theory, but you have a thought?
I don't.
Yes. Well, so I read the district court opinion in Barnes, and they cited a previous Fifth Circuit panel decision that said, they were talking about, well, first of all, they said ordinarily a court considers and they listed the 3 Graham factors as if those were the exhaustive, exclusive things to consider. And then they said in this case, Ontiveros, that in a deadly force encounter, usually 1 and 2, severity of the crime and whether he's actively fleeing or resisting is basically irrelevant. What it really boils down to is, did the officer perceive a deadly threat? The 2nd Graham factor. And the court said it's presumptively reasonable that if the officer perceived a threat of death or serious bodily harm, it's presumptively reasonable to use deadly force. That's what the quote started out as. Mm-hmm. But then in Barnes, the district court interpreted that as it is categorically reasonable in that case, if at that precise moment he has that perception. So it takes a presumption and turns it into a categorical moment of the threat, and that's where it comes from. To the best that I can tell, and no other circuit has been that
extreme.
Yeah. And so,
Anthony, you asked earlier, I mean, what is better? What is better? Is moment of the threat better? And I think when you look at it, moment of the threat, if you are interpreting it as restrictive in such a restrictive fashion as the Fifth Circuit did here, then I think sometimes that's going to be better for law enforcement, right? Why? Primarily because it removes a judge's ability to second guess and to factor in this officer-induced, right, analysis. Because if you look at the Fifth Circuit, Higginbotham himself said if we were allowed to consider more than the moment of the threat, I would consider that the officer's actions here, I would conclude that the officer's actions here were unreasonable because he jumped onto the car. And so it's like, well, hold on a second. You're saying it's unreasonable because he jumped on the car? And in your estimation, based on your background, your training, and your experience, you know that an objectively reasonable officer in this case would not do that? He wouldn't jump onto the car like that? Well, how can you say that? A whole lot of videos out there, a whole lot of incidents of this, of officers jumping onto the car. That is an instinctual response.
Well, not just maybe it's but maybe the argument is that it's a bad instinctual response. Maybe you shouldn't run into burning buildings, right?
Well, but again, it's an instinctual response. And so can we say that that is a conscious choice? And even if it is a conscious choice, is there a basis to support the conclusion that it is the correct choice? Now, Travis, I know you're a big force science guy. And so when I saw this, the study is called The Influence of Officer Positioning on Movement During a Threatening Traffic Stop Scenario. For those of you guys who are familiar, if you're not familiar, forcescience.com, you need to familiarize yourself. I'm gonna plug them because I think they're a great organization and I really like what they're trying to do to help law enforcement, right? They're trying to apply science to understanding the impact of stress on human performance. All good. Basically, what this study did was it analyzed the startle response upon approaching a traffic stop that suddenly turned into a lethal threat, right? And what they found is that officers were vastly misinterpreting or misremembering the path of retreat that they took, how long they're drawing their weapon. And one of the things that I thought was most interesting that applies specifically here is they said out of the 100 plus traffic stop simulations they did in this study, they said two officers definitively would have survived. One of them was a SWAT operator, and one of them was a canine officer. And the thing that they did, instead of retreating and fumbling and taking that second and a half to draw out their weapon before they returned fire, was they aggressed the threat. They jumped into the window and grabbed the guy and ripped the gun out of his hands and then went full on. So you say, if you're familiar with that study, and you say, man, out of these 100 plus simulated traffic stops, they're saying the only two officers who definitively would have survived that encounter are the ones who jumped into the car and grabbed the gun and moved it away, right?
Right.
Well, now if I use that as my basis, doesn't that suggest that jumping onto the car is possibly tactically the best decision I can make?
Maybe. I mean, I think that he's. You can't fault the guy, at least I can, about what he's trying to accomplish there. He's trying to stop that car fleeing away, and even though some people are just going to focus on the underlying crime, but I mean, I think Plumhofer. I mean, I think about if he's trying to escape, he puts other people in danger. I did save a quote here by Ronald Williams. I thought it was kind of. I think it's a good point. He says, "I believe the totality method will open the door to numerous claims that there was not enough de-escalation, a poor or rude demeanor." We probably already have the issue anyway, as far as juries are concerned. A miscommunication between the officer and suspect that escalates into a violent or forceful encounter could be found to be unlawful and basically, contributing to a bad outcome. Totality is better in examination by far, but I fear that totality will be used to say reasonable force was unlawful due to these many smaller factors, which actually ties me in to, and I'm actually very honored that Jim Glennon is here. For those who don't know Jim is over at Caliber Press, and he's a phenomenal instructor, but he teaches this class about, lawful but avoidable, right? You've heard about lawful but awful. His take on it is actually kind of better. It's lawful but avoidable, right? We don't want just lawful outcomes. We want optimal outcomes. And he does believe that there will be more lawsuits because of Barnes. I agree with that. I think so too. What do you guys think? I think that this is going to open the door for a lot more nitpicking.
Well,
behavior.
think one thing that burdens folks with totality of circumstances, once again, everyone on here has a different policy that puts officer created jeopardy sometimes within policies, right? And then every part of the country, it's very vague. Totality of circumstances is vague on purpose, right? Well, that vagueness can hurt us, that vagueness can help us. And I think it's in the back of everyone's minds going, well, is there something that I may do in this totality, even though the force could be reasonable or justified? They're going to bang me on that or fire me on that, or I'm going to get sued on that based on my behavior in the middle of that. And force science, John, you're right. And by the way, I don't know if anybody noticed this, but I did not understand how beautiful John was. I don't know what filter you're using, John, but I need to grab that. I may not be able to, but man,
it's that three-piece suit.
when Anthony blew this screen up, I just became enamored all of a sudden. But I think the vagueness makes us nervous, but the vagueness can also be our friend, because once again, the courts have routinely discussed that you need that flexibility. You have to make split-second decisions with very limited information. And so the vagueness can also assist us.
What about Jim also brings up, and it's also interesting that, was this decision more narrow, broader, or what exactly you expected? What happens now? It's kind of related, but Zach, I think I start with you. I think we had a conversation with this case months before it came out, and I think you were pretty much spot on, weren't you? I mean,
it came out exactly the way I expected it, except for I was expecting maybe a concurrence from Jackson or Sotomayor, but Kavanaugh's doesn't surprise me. But as far as the holding, I said it was going to be a unanimous, very narrow decision, and it is very narrow. It is the moment of the threat where you consider only the millisecond when the officer made the decision to use that deadly force is incompatible with Graham and Connor. I'm sorry, Garner and Graham, and that's it. And that's the holding. Now, I wanted to comment on a quote you had up there. You mentioned it in the majority opinion or in the unanimous opinion. They're talking about the fact, talking about if you can you put that quote, the one
Sure
you
can.
had about
sure can. Is it the one? Is it this one? Or the one before?
Yep, one before that one right there. Okay, so the quote about controlling, such as get right in the middle, such as officers' actions can, so too can officers' actions contribute, such as giving warnings or otherwise try to control the encounter. And then there's a citation to Kingsley versus Hendrickson right there, and the quote from Kingsley, as far as a factor to consider in a use of force, a Fourth Amendment use of force test is whether the officer made any effort to temper or limit the amount of force. That is a factor from Kingsley. So it goes beyond the Graham factor. So that is definitely suggesting that an officer's decision or maybe poor decisions could be a relevant factor in the totality of the circumstances. We'll see where it goes.
I'm glad you brought that up, because they repeated that whole temper, an officer's attempt to temper the situation, which is code for de-escalation.
Right.
They reiterated that in Lombardo, right? That was the jail use of force case.
Yeah, and Kingsley is a pretrial detainee force case, but it's decided under the same standard as field force out in the field. So it is definitely an issue lingering under the surface, and that's really what this case was about. That's what Felix wants to be able to argue. I'm sorry, Barnes wants to be able to argue, is that the officer, in some way contributed to this force. That's where the real circuit split is. The circuit split is on can the fact finder consider decisions the officer made that may not have been the wisest decision, and that's the hard question. And
that's what people.
Mendez,
I guarantee you, the people in this audience, they want to hear the answer to that.
Yeah, we do. We need an answer, because it is a hard question. And how about this there are some pre-seizure things that an officer might fail to do that would render the force otherwise unreasonable. What about a failure to give a warning when feasible when shooting using deadly force against a fleeing felon? Garner. That's pre-seizure conduct that the lack thereof could render an otherwise reasonable deadly force unreasonable. And how about in another context, failure to knock and announce prior to entering a home? It could render the entry pre-seizure contact, failing to knock and announce, could render the entry unreasonable, even if I had a warrant. So pre-seizure conduct or pre-search conduct in that case is considered in other, well, garners of context, but in other situations. So
Yeah.
so maybe it is something to consider.
Zach, we just agreed that there hasn't been any major case law change in 36 years. Do you anticipate officer created jeopardy coming up soon, being the next case that they look at, or
Yeah.
do you have any time frame on that?
So as far as what the next force case, this case they grant cert on, yeah, absolutely. Because that was what Mendez was supposed to address, Mendez, but the Ninth Circuit had that really weird provocation rule that just makes no sense. So the Supreme Court punted there on officer created jeopardy, and they punted here for good reason. I mean, both of these were not in the question presented. These were just not the right cases for it. But absolutely, Travis, the next time they take us, they grant cert on a force case, it is going to be a pure officer created jeopardy. It has to be.
Can you talk about provocation rule that they got rid of in Mendez?
Yeah, and I noticed Jim Glennon asked a question about that. Yeah, so L.A. versus Mendez was a Supreme Court case where the Ninth Circuit had this really weird rule. So that says if we deem a use of deadly force reasonable, but we look back and we find some prior constitutional violation, like for example, an unlawful entry into a home, then the use of force is now unreasonable. And the Supreme Court says that backwards looking logic doesn't make sense. You've already decided the officer was justified in using deadly force. And then you make the inquiry into, well, how did he get there?
Right.
And he did so by violating the Fourth Amendment by being inside the house. So that provocation rule, which is I think a form of officer created jeopardy, no doubt, but that just wasn't the right way to frame that.
Right, because there's a causation issue, right?
Yeah, the death was a proximate cause of the illegal entry, and that's on remand. That's where we end up losing big. The Ninth Circuit said since the entry was illegal, the death was a proximate cause of the entry, and of course it was a but-for cause. Therefore, the officers are liable for the death because the entry was illegal.
Yeah,
not the
and,
force.
and so well, that was that case was in the Ninth Circuit. Remember the one about the guy, the cop going sneakily, surreptitiously up the driveway and end up popping the homeowner.
Yeah.
I guess they gave that cop qualified immunity, but but I also think about a case called Sparks versus Brazula, or is this Brazula versus Sparks? Remember the curtilage case?
Nevada,
Well,
yeah.
right. So we had in that case, we had Ninth Circuit case, but after Mendez, but they had a curtilage violation, which the court found was clearly established. But then the suspect pulled out a gun and was threatening the officers, and they shot him, and they gave qualified immunity. And that probably, even if they analyzed it, it probably would have been fine anyway, because you don't pull out a gun just because a person is trespassing, just with those facts, right? So in that case, the shooting was not caused, I guess, directly by the simple curtilage violation. Maybe that's what you're kind of an example of that.
Right.
Okay, another quote I want to share with you as we kind of move through this, and we're almost done here, but we'll open up to questions that people have. But this is that whole officer created jeopardy business. We do not address here, and a lot of cops we would all like to know, right? We do not address here the different question Felix raises about use of force cases, whether or how an officer's own creation of a dangerous situation factors into the reasonableness analysis. So to use the obvious example, the courts below did not address the relevance, if any, of Felix stepping onto the door seal of Barnes' car. And because they never considered that issue, it was not the base of petition for cert. So I mean, that's, we've been talking about that, but anything else to add to that?
No, I think it's pretty straightforward what they're saying. Yeah.
Yeah. Any predictions about what happens at the lower level here when it goes back? You want to predict? Qualified immunity?
Yeah. There's definitely qualified immunity on not the law not being clearly established. I would like to see them address the constitutional issue, which they don't have to, but they could.
Yeah,
and just get a ruling on the constitutionality.
Somebody did point out attorney friend Robert from Houston that qualified immunity wasn't even mentioned in this case, right? I mean,
yeah,
I'm not smart enough to know why, but I don't know. Maybe.
So let's talk about reports, Anthony. Building totality of circumstances. That's where we've landed here. Totality of circumstances. Document, document, document. Folks, if you're not familiar with it, Anthony and John have some excellent webinars on documentation. Check that out on YouTube. But document every single thing up to the point of that use of force.
Yeah, absolutely. Absolutely. I want to go through a few questions. When I was, putting this together, I said, okay, look, I think that if we can answer these questions, I think we did a good job. The first one was, what are the implications of Felix, this Barnes case for defending or prosecuting 1983 excessive force claims? Look, we kind of talked about it, but do you think things get easier or harder? I think they get a little harder because of the language in this case. I mean,
Yeah, I agree. I think we all want a very specific black and white answer, and we got nothing but.
yeah, and then there's just again that language of at least keeping the door open for officers' behavior to contribute to a bad outcome. It's basic. I think it's going to, it's going to encourage some judges to at least think of the whole, officer created jeopardy issue. They're not going to call it that, right? But they're going to just say, hey, your bad decisions caused a bad outcome. And that was like that before, but I think this case helps allow that to happen, which is, again, I'm not saying it's wrong, right, or indifferent. I'm not. Anything
On those lines, real quick. So you're talking about Judge Higginbottom's concurring opinion, where he said, I think the officer, he created the jeopardy by jumping in the car. Well, that was based on no factual record there. I mean, other than the video, there
Right.
was no expert testimony on police practices, and so he's just making that bold assertion
Yep.
purely on his opinion, and I can guarantee you plaintiff's attorneys are going to quote that
Yep.
in their motions.
Yep. And
Your
I know,
briefs.
Mike, Brave talked about the 2020 hindsight. But look, it's one thing to say something. I mean, I think we all can agree. I mean, right? It's one thing to say, hey, we don't use hindsight 2020, but it's another thing to say that we still don't look at the performance of the officer and today and then say, hey, what facts are relevant here, right? In other words, let's not misunderstand what they mean there. It's just that you can't go back in time. The facts are what they are, right? I think that's so. Of course, we look things retroactively, and we want to see if the officer was objectively reasonable. Anything else on this? This prosecuting 1983 excessive force claims. Again, I think it's a little harder. Now that the case is headed back to trial, is qualified immunity going to be argued? I think we kind of answered that too. I think you just argue that what Felix did was actually reasonable, and I'm not. We don't know enough facts but from what I see, I don't think that's not a frivolous argument to any degree. But even if it was unreasonable, which I don't think it was, he gets qualified immunity. Anything else to add on that? Zach, John?
He's definitely getting it.
He's definitely getting qualified immunity.
Yeah. Oh, yeah.
Absolutely. And absolutely. The family should not see a dime from this case. I'm not trying to be, harsh about it, but this is not the case where a family gets paid big money, from my view. Barnes should never have tried to flee that traffic stop under these facts. And and the officer reacted the way he did. The next factor, does this ruling expose law enforcement agencies to greater liability risk? Well, again, these are kind of related questions. Travis, this is kind of a lot of it in your wheelhouse. Jim Glennon, this is also in his wheelhouse.
Well, I think it's the same risk that always exists, right? I think it's, totality of circumstances is a lengthy process leading up to that contact. I think it gives more information for people to critique. It also gives more information for us to be able to justify what happened. So once again, it's a balanced approach. But I think because of that, yeah, I don't think it's greater. I think it's the exact same. And I think that's different in different parts of the country and different politics and different things that are going on. I mean, we have officers working under policies right now that are exposed more because of their policy than other officers in the country, because you can obviously develop policies that are stricter than Supreme Court guidelines. So I don't think it's changed. I think the risk is still there.
Yep. Mike definitely said something that I completely agree with. And this is that we can definitely agree on this one thing. The risk of who appointed the judge is a much greater risk in this decision. I definitely agree with that. Judges do matter. Sometimes sometimes people will say, "Oh, it's an Obama judge, it's a Clinton judge, it's a Trump judge," and they say it in a derogatory manner. Be as you may, there's definitely a lot of politics in judges, and it shouldn't be that way, but definitely true. Ronald says he thinks that the use of force would be unlawful. I would love to hear why you think that. Okay. Another question is, how should police agencies revise training and policy post Felix, if at all? Again, this might be a Travis question.
Well, once again, I don't think it moves the needle. I think you should have policies and training that takes totality of circumstances in play. That's why scenario-based training is important, because you can build a lot of totality of circumstances in there. And I think your policies should talk about all those circumstances and totality of circumstances and how to document that. I don't think that changes. We may have some agencies that haven't been doing it that need to improve on it. I don't think it changes too much, though, if they've been doing what they're supposed to do.
Yep. Zach, anything?
I mean, I was a trainer for 10 years, and our force training for our department was we emphasize not putting yourself and taking unnecessary risks. There is an assumption of the risk being a police officer, but we don't have to assume unnecessary risks. And I think for the modern progressive, and I don't mean that in the political sense of the word, progressive agencies are already doing what we're supposed to do, not training not to jump on cars, in cars.
Correct. Yeah, not to jump on cars.
Yeah,
Think about your actions.
Yeah,
I was looking at a case. Maybe maybe it was from Jim's class, but just about this husband. In a detached garage. He was having a fight with the old lady type deal, an argument. The cops arrive. He's pretty much barricaded in this detached garage, and he's not going anywhere. He doesn't want to leave. He wants to get tools, whatever it was. And the cops push in anyway, like, you got to go. He held up a hammer or something like that, and the cops still pushed in. And predictably, of course, the guy got shot and killed. And I look at that and I'm like, that's where overtime comes in, right? Why are we pushing our way in my view, on that situation where hopefully they could have just slowed it down a little bit and had a better outcome. That's that whole lawful but avoidable type thing. So, all right. And all right. So there's that. And I think one more question I have. Okay. We already talked about Kavanaugh's and concurrence. Zach, I think you did a great job on that. So he did say there was 4 options the officer might have. All of them seem to be problematic. Let the driver go with the risk of escape or future danger. That doesn't sound that good. Initiate a pursuit. That doesn't sound that good. Shoot at the vehicle. Dangerous and ineffective. We don't teach that anyway, but it doesn't sound that good. Jump onto the vehicle. That doesn't sound that good. So in other words, it's all tough. It's all tough, right? If it's so easy to let these guys go, then you're what you're looking at is a lot easier than the way I look at it. It's very complicated. Anyway, anything else to add on that?
I mean, we can't let the driver go, right? And I think that the concurrence does an excellent point of that, is to say we're empowering criminals, we're emboldening criminals. If they know that they can just drive away, why would anyone ever stop for us?
Yeah, if that's the answer. I understand. I understand the risk and the reward and all that kind of stuff. But at the end of the day, where we are in 2025, these are not easy answers. Real quick, we're going to change over to the Search and Seizure show, where we're going to open it up and people can come on and ask questions, clarify about this, or hopefully some other search and seizure issues. Just kind of want to give a shout out real quick. Please, if you guys are interested in hosting us, bringing us in for search and seizure training, or some courses that Travis has, that John has, please contact training@bluetogold.com. This is John has a response to resistance class. This is his use of force class. It's new. It's brand new. He put a lot of work and time into it, so we're really excited about it. This is an example of where it's going to be. Lafayette, Louisiana, Victoria, Texas. I didn't do all of them. Travis also has classes on the books, but Travis, when I made this PowerPoint, I'm sorry. I need to put your calendar in there, and I do Seconds for Survival, and I let you down on that. Law enforcement liability, kind of another related class that we have, a brand new class that Chris McFarland is teaching, and that's where some of his classes are. All right, but just go to bluetogold.com, find all of our classes and so forth. Now we're going to transition to the search and seizure show. We have a lot of people still here. They probably want to ask some questions, but for those who watch this online, on demand, I should say, I really appreciate your time. Hopefully this is giving you some context. This is not an end of the world case by any means, but it certainly is a very important case for, especially for those cops that are working in those circuits. Travis, I appreciate your time. John, I appreciate you sitting there and looking pretty. I don't think you said one word throughout the whole, you said about 2 words. Okay. Now we're going to the search and seizure show. Okay. We need to hear more from you. And then Zach, I appreciate your time. Stick around for a second. Okay. Thanks guys. And go to bluetogold.com and sign up for next week's webinar and so forth. We do these every single week.